In this video, we're going to be discussing a very exciting case. It's truly a roller coaster ride through many Fourth Amendment and Fifth Amendment issues, including abandonment, plain view doctrine, inventory searches, Miranda, community caretaking, and others. So let's stay tuned and let's take a look at this case. In this case, we'll be discussing United States versus Chavez, a 2021 very recent 10th Circuit case. And here's what happened. There was a hot pursuit of a vehicle, and allegedly Mr. Chavez was the driver. The pursuit ends on a private dirt road. The road is about 200-300 feet long, and at the end there was an RV and a trailer parked at the end of the street. Now, when the dust finally settles, the first officer calls for backup. But the vehicle did not have Mr. Chavez inside. The lights were still running, but the driver was gone. So the first officer starts looking for Mr. Chavez. When the backup arrives, the second officer notices that the vehicle is not put in park. The transmission is still in drive. And so concerned for the safety, he opens the door and puts the vehicle in park. But while doing that, he notices that there's a firearm inside the vehicle. So he doesn't touch it, he closes the door. He then tells the first officer that he saw a firearm inside the vehicle. Mr. Chavez eventually appears out of the RV. With this information, the first officer, without giving Mr. Chavez his Miranda rights, asks Mr. Chavez whether he's a felon. And because he's a felon with a firearm, the first officer puts Mr. Chavez under arrest. They walk past the car, and the first officer also notices the firearm inside the vehicle through the window. Now, the officers decide to impound the vehicle. So they go inside, they take the firearm, and try to inventory other things inside the vehicle. At that point, a woman appears from a trailer and tells the officers that it is her car. So the officers decide to give the vehicle back to the woman and not actually impound it, because she appears to be the real owner of the vehicle. And Mr. Chavez, by the way, is allowed to use it according to this woman. But here's an issue. The officers take the firearm, and the question is, are they allowed to take the firearm? Or is this a violation of the Fourth Amendment rights of Mr. Chavez and the gun should be suppressed? So let's find out what the court tells us. Let's methodically go through all the issues. The Fourth Amendment protects you against unreasonable searches and seizures. And searches and seizures done without a warrant are per se unreasonable. And here, of course, we're dealing with a situation where the officers simply took the firearm, they seized it without a warrant. So the government makes the first argument, and they say that the property is abandoned. There's a slew of cases out there dealing with people throwing away their property into the trash can or throwing the evidence out the window as they're driving away from police officers. That property is abandoned. But here the court says the vehicle was parked on a private dirt road outside of Mr. Chavez's RV. So the court rejects the argument that this is abandoned vehicle and the firearm. This is still Mr. Chavez's or that woman's vehicle. The court says that Mr. Chavez still had an expectation of privacy in the vehicle. And if you forgot what the expectation of privacy test really is, take a look at this video. I've discussed that topic before. Next, we're going to move on to plain view. Under the plain view doctrine, the officers don't need a search warrant when they see something in their plain view. For example, the officer here opened the door and he could simply see the firearm in the vehicle. And here there's some issue with the fact that he opened the door, but for the second officer, he never even opened the door. He could see the firearm through the window because it's in plain view. But the court tells us that yes, the officers are allowed to search, meaning they're allowed to see the firearm. It does not give them the right to seize the firearm or take it. So far, the government still has a problem explaining exactly the reason why the officers should be permitted to keep the firearm. So they move on to their next argument, inventory searches. In this situation, the vehicle was being impounded. And when the vehicle is impounded, so the officers don't get blamed later for lost or stolen or damaged items, the officers are permitted to inventory the items inside the vehicle, including those that are potentially illegal, such as evidence, drugs or guns or anything else. But there's two problems with that argument. First, under this particular sheriff's policy, the officers were not permitted to impound vehicles on private property. And here, this particular vehicle was parked on a private dirt road. And even if that wasn't true, we know that the impoundment was called off. After all, the woman came out and said it was her vehicle, so the officers never impounded the vehicle. Next, the government argues that the officers were permitted to seize the firearm under the community caretaking exception. Under this exception, the officers can take the firearm from public where they find it unattended. For example, if they find the firearm in a public park, children can come along, take the firearm, and somebody can get injured. In order to protect the community, the officers can take that firearm into their own possession. But in this situation, the court tells us that it would take a daring child, a vandal, or a thief in order to come to a private property, break into somebody's vehicle, and take the firearm. So the community caretaking exception doesn't take off. The government then argues that Mr. Chavez's own admission that he's a felon provided probable cause for the officers to seize the firearm. But in this situation, the court tells us that that admission was not done after providing Mr. Chavez with Miranda rights. And if you remember Miranda, and I have a video just about it posted last week, so take a look at it. To remind you, Miranda rights have to be given when the person is in custody and being interrogated. And in this situation, this is a perfect example. Mr. Chavez was not free to leave, so he was in custody, and he was being asked incriminating questions where the answers could be incriminating. Here, whether he was a felon, and because he was not provided Miranda warnings, that statement cannot be used in order to justify the seizure of the firearm. And finally, the automobile exception. Under this exception, the officers can search and seize items from inside the vehicle if they have probable cause that a crime has been committed, and that's the evidence of the crime. But in this situation, we're dealing with a state with one of the most relaxed gun laws in the country. And there's nothing illegal in keeping the firearm inside the vehicle concealed or otherwise. So the officers still have an issue with proving that there was probable cause to the court. So the court tells us that the automobile exception does not apply. And if you ever feel that you go through the case and you never win, this is a perfect example where somebody goes through all the issues and the Fourth Amendment and the Fifth Amendment comes to save the person from criminal charges. If you enjoyed this video, please click like, subscribe, hit that bell notification button, and next time I post, you'll be first to know. And I will also urge you to comment below. What do you think the officers were supposed to do with a firearm now that they saw it inside?